Hi everyone, I am Ayushi Jain from School of Law Modi University working as a legal intern in LEXIS and Company. Today in this video I am describing about Doctrine of Pleasure. Doctrine of Pleasure, I divide the Doctrine of Pleasure in two parts. So in this video I am discussing the first part. The Doctrine of Pleasure, the civil services were introduced in India during the British rule, therefore their rule and regulation were also applied in India as per the need of the country. After the independence of India, the civil service were provided constitutional status. The law of England still have a greater influence on Indian law. The Doctrine of Pleasure, one of the concepts which have been introduced in India from British rule. Under this doctrine, the civil servant was regarded as a servant of the crown and this servant served at their pleasure. What is the meaning of Doctrine of Pleasure? As mentioned before, the doctrine is originated in England. In England, the crown is regarded as the executive head and the civil servant are a part of executive. The Doctrine of Pleasure means that the crown has the power to terminate the service of the civil servant at any time they want without giving any reason of termination or to the servant. Thus, the civil servant work at the pleasure of the crown, which can be removed them at any time. When the civil servant are removed from their service, they do not have the right to sue the crown for wrongful termination, and they do not or cannot ask for damages they undergone for the wrongful termination. The doctrine is based on the concept of public policy, and whenever the crown feels that the civil servant are removed from the office because keeping him of the way against the public policy, the crown can remove such servant. What is the position of Doctrine of Pleasure in India? The Doctrine of Pleasure is also followed in India since the President of India is the executive head of the union and he enjoys the same position as the crown enjoying the England. The President had vested with the power to remove a civil servant at any time under the doctrine. While the doctrine has been adopted in India, it has not been blindly copied in the same manner as it is followed in England, and therefore are some modifications which exist in India adoption of their doctrine from that England. In India, Article 310 of Indian Constitution embodies the provision for the doctrine. According to the Article 310, except for the provision provided by the Constitution, a civil servant of the Union work at the pleasure of the President and civil servant under a state work at the pleasure of Governor of the state. This implies that the operation of the Doctrine of Pleasure can be limited by constitutional provision. Under the Constitution, the following are excluded from the operation of this doctrine. First, judges of Supreme Court, the judges of High Court, Chief Election Commission and Comptroller and other Attorney General. Thus, this doctrine is not absolute and is subject to constitutional provision. The civil servant can also be excluded from the operation of this doctrine because they have been provided with some protection under Article 311, and thus this doctrine application can be limited to the civil servant as well. What are the constitutional safeguards for the civil servant? The civil servant have not been provided with the constitutional status under the Article 308, but they have also been granted some protection under 311 by providing the civil servant with the protection, the confidence of the public in the civil services and maintain. This civil servant are also provided with the assurance that can be honestly carried out of their duty without any fear of unjust or lawful removal from their office under this doctrine. The following are protection available by the civil servant under 311. The first, under clause 1 of Article 311, a civil servant can only be removed from the service by the authority person had appointed him or another person who can be same authority or rank as the appointing authority has. So any person who is subordinate in according to the appointing authority cannot remove a civil servant in case he do not remove him. The removal will not be valid. For explaining this, I explain one illustration like A civil servant who appointed by the C, B who is a subordinate of C, remove A from his office. Here, such removal is not a valid removal because B is not the same authority or the rank as C has. The C is the appointing authority. But if D, who has the same authority as C, remove A, then such removal will be valid under clause 1 of 311. The second, the reasonable opportunity to be heard under clause 2 of article 311, the civil servant are provided with the right of being heard, the right embodied with the principle of natural justice by giving a chance to the civil servant by provoke his innocence. First, as per the clause, to remove civil servant from his position, the following steps should be followed. First, holding an inquiry in allegation made against the civil servant. The inquiry is known as a departmental inquiry. Second, providing the accused civil servant with the information about what the changes have been leveled against him. Thirdly, providing such a civil servant with a reasonable chance of being heard in the case. This protection is very important because under this article the civil servant is provided with a reasonable opportunity being heard. While the clause mentions reasonable opportunity, it does not define its meaning. When no clarification is provided for the meaning of the reasonable opportunity, it should be appear ambiguous protection because there is no method to determine whether a civil servant was provided with a reasonable opportunity or not. Thus, the meaning of reasonable opportunity has been taken in the same meaning as the principle of natural justice understood. Thus, a reasonable opportunity means that the accused is given a chance of presenting his side of a case in order to disprove the charges levied against him, and he should also have the chance to first present his argument before the body which is conducting the inquiry. Second, giving his statement as a witness. Third, listen to the statement of the witness against him. Fourth, cross examination of the witness. When such opportunity is provided to a civil servant, the requirement of reasonable opportunity being afforded to him will be fulfilled. Illustration to this: A is a civil servant and corruption charges has been levied against him. A department inquiry is made to look into this matter and find out whether A is guilty or not. But A is informed about any of the charges which is made against him, and he is not being a single opportunity to argue against this allegation and present evidence. This inquiry concluded that A is guilty without listening to A, as a result A is removed from the post. Such removal can be constituted by A in the court, and it will be held that departmental inquiry was not valid, and removal of A cannot be deemed to be valid as a violation of provision of Article 311 Clause 2. Thank you. In the next video, I am continuing with this topic only.